My name is Richard August, and I'll be your host. Our guest is Richard Sinapi, Managing Attorney of Sinapi Law Associates Limited. He has co-drafted and successfully lobbied for the passage of numerous pieces of legislation, and additionally, Mr. Sinapi is an active volunteer for the Rhode Island ACLU. Welcome back to State of the State.
Glad to be here.
Our topic tonight is the gun control bills that have been passed in the last three sessions of the General Assembly, and also the landmark Bruen case that was handed down by the United States Supreme Court just last month. Well, last week, our guest was attorney Frank Sakosha, who was the president of the Second Amendment Coalition in Rhode Island. Going back over the last three sessions of the General Assembly, a series of bills that purport to make us safer by controlling guns have been passed. 3 years ago, then Governor Gina Raimondo signed what was known as the Red Flag Law that permits police to go into a home and seize the firearms in that home on a warrant that is based on someone's claim that the person in the home is a threat to himself, his family, or society at large. We have had guests on this program who point out that there are serious questions about due process under this law. And last year we saw the passage of the state's Safe Schools Act aimed at prohibiting holders of a concealed carry permit from carrying a gun on school grounds unless, of course, they are a retired police officer. There was at the time already a law in the books that prohibited the possession of a firearm on school property. And the anti-gun lobby claimed that this was insufficient, and so that law was passed. Now this year, amid much fanfare and wearing a red Moms Demand Action t-shirt, Governor McKee signed into law 3 common-sense gun control bills enacted in the wake of the tragic school shooting in Uvalde, Texas. In addition, the United States Supreme Court handed down a major 6-3 ruling called New York State Rifle and Pistol Association versus Bruen that favors the Second Amendment. First, allow me to point out that Article 20 in Section 1 of the Rhode Island Constitution reads as follows: "The right of the people to keep and bear arms shall not be infringed." Period, full stop. There is no militia clause in the Rhode Island Constitution. And to infringe means to encroach upon, to invalidate, or to go beyond the limits of. Mr. Sinapi, isn't this exactly what's happening in Rhode Island, that the rights are being gradually encroached upon or whittled away?
Well, I think that the right to keep and bear arms has to be understood in historical context. Even at the time that our Constitution was adopted, there were regulations in effect on who could own firearms and what types of firearms you could own. So whether this infringement is inconsistent with the historical types of regulations and historical purposes would have to be examined. I mean, typically it's to limit it to the extent necessary to protect public health and safety. If you go in and you read other provisions of the Rhode Island Constitution, which I'm not prepared to do today, but I think you'll find other rights that are enshrined in a similarly unqualified fashion, which must be read in conjunction with that right, like the right to pursuit of happiness, and life and liberty, So I'm not prepared to really get into it, but I think you have to read the Rhode Island constitutional protection in that context.
And the Second Amendment, for that amendment, what you're saying is we should have to look at the historical context and the times in which these bills and laws were passed?
Because they weren't absolute. At the time, they weren't intended to be absolute, and if you read it that way, then every right is absolute. But we know by constitutional interpretation and constitutional decision laws and the historical context that no law is absolute. The right to free speech is not absolute. There's rights, you can limit it, laws of defamation and obscenity and incitement, to name a few, can limit your right to free speech. No right is absolute. A lot of the limitations we recognize today in the First Amendment have some historical context. However, the historical context must be understood in terms of modern economic, social, and technological changes. Like, for instance, they didn't have moving pictures back in the time that there was a First Amendment was promulgated. So the type of obscenity laws that we have in place now, as they apply to movies, as they may apply to radio and TV, not something that was contemplated at that time. So now we have to interpret it in conjunction, again, with technological, social changes. And not to do so is you do it at your peril, and it then becomes, I think, destructive and not promoting the common good.
Okay. The first bill passed in this session is a ban on openly carrying a rifle or shotgun in public, except when you're hunting. I have spoken to a number of gun owners, and they don't seem to have too much of a problem with this legislation, but we don't really see many people walking around with a loaded rifle or shotgun slung over their shoulder. So do you think this was more of a cosmetic thing, or was it a true victory for gun control?
I think any limits on the use of firearms, which are a highly dangerous weapon, highly dangerous instrumentalities, is a step in the right direction, however marginal. I think a lot of it may have been fueled by, the January 6th, march on the Capitol, with people openly brandishing weapons and whatnot, may have had something to do with it. But I think it also is the fact that, again, generally to go about your life in a law-abiding, peaceful fashion with some sense of peace and security and not being anxious, you don't want to see people walking around, with loaded firearms slung around their shoulders. For what purpose? To what end? Is there going to be like an attack from the British?
But you're saying that there were people, protesters, rioters, whatever you want to call them, on January 6th that were openly carrying firearms?
Yes. Yes, part of the process, yeah. By the way, I'm not saying it was lawful in D.C. to do it at the time, by the way.
Next bill is raising the age to buy any firearm from 18 to 21, and previously someone over 18 could buy a rifle or shotgun in Rhode Island. This was probably in reaction to the shootings in Texas and Buffalo, New York, and now in Highland Park, Illinois, where the perpetrators are under 21. Now, one of the arguments made by the gun control lobby is that a person has to be 21 to buy a beer, a pack of cigarettes, a lottery ticket. But on the other hand, 18-year-olds are adults in the eyes of the law and are believed to have the mental capacity to cast a ballot. They're allowed to vote. And they can join the military, where they're going to be issued assault weapons and pistols with high-capacity magazines. So it seems to me that the recent tragic shooting on the 4th of July in Illinois really illustrates how ineffective these kinds of laws are, because the young man there was obviously a disturbed individual and was able to secure a weapon, magazines, and ammunition. So isn't it just really a knee-jerk reaction to pass laws like this at this stage?
Again, I reiterate, any reasonable restriction on the use of firearms is a step in the right direction, given that 45,000 people a year are the victims of it, and it's the second highest cause of premature death. I could go on. But in terms of, in actuality, I mean, an 18-year-old acting, I put a little more faith in somebody 21-year-old acting a little more responsibly than an 18-year-old. That is something that's, quantifiable to some statistical degree. Is it going to have an earth-shattering effect on safety of firearms, or reducing firearm violence and death? In and of itself, no. But if I may, that argument is used for every reasonable limitation imposed on the use of firearms. For instance, waiting periods for all firearms, reduced gun magazines, background checks, red flag laws, banning black rifles, banning bump stocks, every single one, you could say, well, gee, that's not going to solve the problem. Of course it's not going to solve the problem. Or you can say, oh, well, criminals don't follow the laws. Well, gee, why would we have drunk driving laws? Because alcoholics are going to drive drunk anyways. Those arguments don't hold water because, no, first of all, again, the second argument doesn't hold water because, again, alcoholics, they're going to drive drunk anyway, so why have a law against it? So criminals are going to get guns, so why have a law restricting it? Or restricting magazines, because criminals are going to get it anyways. That's not logical, okay? It happens, but that's why we have laws. So we can impose them and we can restrict people and deter them from doing it. The second thing is that these laws will have some marginal benefit. No one is going to solve the problem. But together, you have marginal benefits. For instance, if you look at nationwide, the top 5 states in preventing firearm deaths have 2 things in common, which we have. We have licensings and/or waiting period requirements, and 2, we have the red flag law that allows police or governmental officials to take court action against those who have firearms and deemed to be a danger to themselves or others. The safest 5 states have those two restrictions in common. So there is some correlation between a safe state and firearm regulation.
You use the term licensing. What specifically are you talking about? You don't really need a license to buy a firearm, say in Rhode Island.
Waiting period, Rhode Island would qualify because it has either a licensing requirement or a waiting period.
The waiting period in Rhode Island is 7 days, and basically it was put in place to allow the municipal governments to run a background check on the individual. So there's a misconception, I think, that the waiting period is in there to somehow reduce firearm violence, but basically what it is a period of time so that municipals can respond to background check.
I don't know, I'm quoting the statistic. Whether or not there's an additional statistic that show those states with waiting periods also did background checks during that period. I don't know the answer to it.
Okay. So finally, we have one of the highest priority bills for the gun control folks passed. And it bans the possession of what are called any detachable ammunition feeding device, more commonly called a high-capacity magazine, that holds more than 10 rounds. Now, the bill passed the House and Senate Judiciary Committees, got out of committee on highly technical grounds, but they passed the full legislature. Not every state that has a ban places the limit at 10. For example, Colorado says it's 15, in New York it's 7. Vermont, which is a constitutional carry state, places the limit at 10 for rifles, but 15 for pistols. Does anyone know when or where 10 became the magic number for this, for magazines? Is a 12-round magazine 20% more lethal than a 10-round? Do you have any idea where that originated?
I have no idea.
Okay. And it's also interesting to note the House of Representatives, the Federal House of Representatives, on June 8th, passed what is called the Protecting Our Kids Act, which sets the limit at 15 rounds. So I don't know where 10 came from either. So I heard the AG, our Attorney General Peter Nerona, say on a radio talk show locally that he knew of a situation where police served a warrant for a hit-and-run accident and found a 50-round drum magazine and a 30-round magazine in the apartment. There was no ammunition and there were no guns. The Attorney General said he needed this law, the high-capacity magazine ban, so, quote, he could have something to charge the guy with because he must have had a reason for these magazines. Should we be passing laws so the Attorney General has something to charge people with?
I don't know what the motivation of the Attorney General to propose a law. I do know, again, that there is marginal benefit from limiting the size of these magazines, because if you want to take the Second Amendment at its historical purpose, like do you need a 50-round thing, ammunition for self-protection against who? This is not the Wild West. This is not some South American country or some Mideast country that's in upheaval. This is a orderly, society of laws, and it is stable and safe. So to say that you need that in this context, again, I don't see the historical analog that would say that, yeah, you need it. And not for anything, but again, this whole historical thing is hypocritical, because if you want to look at it historically, first of all, when the Second Amendment was passed, not a lot of people had pistols. They were expensive, they were very inaccurate, and you're likely to hurt somebody else as your intended target. So to say now the Second Amendment protects, handguns like it's some, holy grail, based on historical analog, is totally hypocritical. But I digress.
No,
Sorry.
that's fine. I spoke to a firearms dealer just before the bill passed, the high-capacity magazine bill passed, and I asked him if his distributors would take back all the high-capacity magazines he had in inventory, and he replied no. I asked what about the high-capacity magazines that came standard with the guns that he had in inventory? Would the manufacturers take them back and exchange them for 10-round magazines? Again, he replied in the negative, and he said, in fact, there are some firearms for which a 10-round magazine is not available. So, under the law, dealers and citizens have 180 days to get rid of all high-capacity magazines in their possession. Doesn't this amount to a government taking of private property without compensation?
Well, this is certainly not the first time in history in which a commodity or a item or product was deemed unlawful and prohibited. Go back to Prohibition. People had, liquor factories, businesses, inventory. It's no different. It's been done before. It can be done again. Two ways I would respond is, first of all, with the internet, you can sell anything, and there are many states where it's still legal. Secondarily, whether or not there is a historically supportable takings claim, I don't know. I haven't researched it. If it is, then you got to pay for it. I mean, it's that simple. But I don't think it's a reason not to, again, try to place reasonable limitations on firearms.
Well, there is no provision in the law for compensation. It's, that's why the question came up. They're simply saying you must get rid of them in 6 months, or else you're going to be subject to 5 years in prison or or a $5,000 fine. And here you got, never mind an ordinary citizen, but a man whose business had a legal product and declared suddenly illegal. If he goes on the internet, what this dealer said to me is, yeah, they know what the situation is, and I'm going to have to sell it at a deep discount. I'm going to lose money because these other places that will, I would contact know darn well what Rhode Island's doing. So that's what I'm saying. It's
right, but I think you misunderstood what I was saying. If there is a valid takings claim that they have, you don't invalidate the law. You give them compensation outside the four corners of the law itself. And again, I haven't researched the issue. I just made the point. It's not the first time where items or commodities have been ruled unlawful.
Let's move on to the Second Amendment ruling by the United States Supreme Court that made headlines last month, where they ruled 6-3 that the New York law requiring a showing of need to carry a concealed weapon was unconstitutional, and that the Second Amendment extended to an individual's right to carry a firearm in public. Now, the previous landmark decision called Heller in 2008 said that the right to own and possess a firearm is an individual right, and that a gun could be kept in one's home for defense. Now, the vice chairman of the Rhode Island Coalition Against Gun Violence, Willis Peter Bilderback, called this ruling, quote, extremely dangerous, And he said, no court decision is going to stop the coalition, meaning his organization, from keeping Rhode Islanders safe. Now, it seems that the gun control crowd bases their arguments on public safety that trump a constitutional right, and they kind of tend to speak from the moral high ground. Is that a fair depiction that I've just given you?
I'm not sure. I'm not sure anybody really knows what the Bruin decision says. It's not even 3 weeks old, and the commentators and pundits are still, tearing apart whatever 80 pages or whatever it is of the majority opinion, the concurring opinions, and the dissents. Okay, so what I say here is going to be memorialized electronically forever, and someday people may say, well, he's dumb because that's not what happened. That's not how it's interpreted, but I'll give you the short of it, okay?
Sure.
On the one hand, the Bruin decision is a disaster for public health and safety as it relates to firearm regulation, because they did something unprecedented in constitutional interpretation. As you know, and as they said in Heller, not every constitutional right, no constitutional right is absolute. There can be reasonable limitations placed on that. And the standard tests for that are, one, is there a compelling governmental interest that's narrowly tailored to achieving that end? Or, depending on, again, the right involved, it could be an intermediate test. Is there a substantial government interest that's advanced by the limitation or regulation that is under scrutiny? That's the test. No constitutional right is absolute. For the first time, the majority decision says that there is no second prong, okay? All you're going to look at is the first prong. And this is how you're going to look at it. What is the scope of the right as it historically existed at the time of the adoption of the amendment? And what were the regulations historically comparable that were in place at the time? That's a disaster. For what I said at the beginning of this show, you cannot interpret and apply an amendment as it was understood during totally different technological, social, economic, political environment. You cannot do it. It's impossible. It spells disaster. And potentially, that interpretation, if you take it on its face, is disastrous, because what limitations are you going to place? What regulation were there of firearms back in the day? Again, the second problem you got is hypocrisy. I said it before, I'll say it again, because what the majority does is they disregard any laws in place at the time involving regulation of firearms and say, well, that was the outlier, or that was a minority decision, that was only here, that was only there. And they say, oh, this is what the law is. So it is fraught with all kind of pitfalls. It provides no guidance, and it's a potential disaster. The concurring opinions try to save it to a certain extent by saying, well, we still haven't said, what firearms may still be banned, and we still haven't said, what regulations you could put in place on gun ownership specifically, or what people might not be able to possess a firearm. It might be prohibited. But I got to tell you, it is disastrous on its face. Again, someday somebody may look at this and say, oh, Dick, that's not how it was interpreted and applied. I'm just telling you that I'm floored by it. I got to be honest with you.
The facts in the case pointed out that New York's famous Sullivan Law was being, I'll say, capriciously applied, because there were people, particularly in entertainment and sports celebrities, who were being granted concealed carry permits for New York City specifically. And yet there were people who had threats on their lives and so forth who were being denied. And that was the problem, and that is why the court said, wait, you can't simply begin to discriminate if you have a law, and if you had a showing of need, you should be able to get it. Let me just quote Justice Thomas' conclusion in that case, and he said, quote, we know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. He said it is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion, and is not how the Second Amendment works when it comes to public carry for self-defense. So that was the rationale of the justice who wrote the majority opinion.
Yeah, well, that's not exactly true. First of all, every constitutional right, even the First Amendment, can have pre-qualifications in very limited situations. Prior restraints almost unheard of and unlawful. But there are situations, particularly dealing with national security, where it might apply. So to say that, you know, this is the only right where you may have to make a showing, or which could be a bridge without a showing, is not exactly true. The second problem is, and it's really a bad problem, and why it's such a horrible decision, is that basically the Bruin decision was decided on the pleadings. It was not decided after full discovery and full analysis of exactly how this law was being applied in practice. It was decided on its wording based on anecdotal arguments about how it might be interpreted in an arbitrary fashion. Again, disastrous decision, improperly done procedurally and substantively. Again, like I said, totally just undermining or upending constitutional law by removing the means ends test, that is, whether the restriction was reasonably related to the restriction. And so I got to tell you, I don't agree with that decision. Now, was the New York law, the most artfully crafted? Probably not, but there was some guidance as to how it was to be applied. There were judicial appeal for those decisions. So again, the problem we have here is they are elevating the Second Amendment to a right that is preeminent of all others. I think there's a quote in the Bruin decision that the Second Amendment is the very product of an interest balancing by the people, and it surely elevates all other interests, the rights of law-abiding, responsible citizens to use arms for self-defense. I mean, it's like raising that as like the most important right that we possess, and therefore there can be no governmental interest that's balanced on it, unless historically there was some governmental regulation for that purpose. Again, the firearms that they're recognizing nowadays, with their lethal capacity, with the multiple rounds, with their accuracy, with their range, and they're saying we're going to look to the limitations that was imposed in 1791, and if they didn't exist then, we're not going to apply them to these weapons, and then hypocritically say the Second Amendment only applies to weapons commonly in use at the time, and then tell me that a 45 with a 15 mag and that could shoot off how many rounds per second, it is way more accurate, and that is commonly used by analogy. I mean, it's hypocritical, it's dangerous to constitutional law and constitutional interpretation, in my opinion, and the lower courts had it right, and hopefully this gets straightened out, because I don't see a constitutional amendment on the horizon.
Well, one was filed today, by the way, and we're out of time. I'd like to discuss it with you. However, we want to thank you, Mr. Sinapi, for coming on the program. As regular viewers of this program know, we have tried for several years to get people from the gun control side to come on this program, and they've either ignored our invitations or declined to appear. So we want to thank you for coming. Perhaps we can have you back in the future when the Bruin decision gets a little clearer. Thank you very much for coming on State of the State, and thank you for watching this edition.